seated.
All right, we're back on. Defense President, represented by counsel, Mr. Gough.
Yes, Your Honor, I have a motion to make. This time we would ask that the Honorable Reverend Jesse Jackson, who I believe is still here, of course, he is, Your Honor, I think we all know, an icon in the civil rights movement. He, not just a witness to it, he is the personification of it. And in other circumstances, I think everybody would be happy to have their picture taken, maybe get an autograph. But in the context of this trial, we object to his presence in the public gallery inside the courtroom. We note that there is a jury assembly room capable of holding, depending on how we socially distance, several hundred people, where these proceedings are being televised live in real time. The issue that Ray brought up previously is how many pastors does the Arbery family have? We had the Reverend Al Sharpton here earlier, last week, and I'm not keeping track, and I think the court has indicated the court doesn't intend to ask anyone to keep track of who was in the gallery. But I don't know who Mr. Jackson, Reverend Jackson, is pastoring here. My understanding is, and I was given names, that the Arbery family have local pastors. They also have attorneys. Mr. Arbery, Marcus, has a team of lawyers to comfort him through these proceedings. Certainly, Ms. Cooper has been amply comforted by her legal counsel. And we are concerned about whether it's conscious or unconscious, the impact of their presence with respect to the jury and with respect to the proceedings in this case. And I guess the next question is, which pastor is next? Is Raphael Warnock going to be the next person appearing this afternoon? We don't know. Your Honor, I would submit, with all respect to the Reverend Jesse Jackson, that this is no different than bringing in police officers or uniformed prison guards in a small town where a young black man has been accused of assaulting a law enforcement officer or corrections officer. And as I have noted before, the city of Brunswick is indeed a fishbowl. Your Honor, I understand that the court, maybe I misunderstood the court the other day, but I think the court had indicated it was the court's understanding or assumption that the Arbery family is giving up seats in the public gallery so that these gentlemen may be present. With all due respect, Your Honor, the seats in the public gallery of a courtroom are not like courtside seats at a Lakers game. There are no First Amendment rights in the public gallery of a courtroom. There is no standing of any particular individual to be present in the public gallery of a courtroom. And there is no reason for these prominent icons in the civil rights movement to be here. This is a case that has been postured in the media, I believe, by Marcus Arbery's attorney, Benjamin Crump, if not Lee Merritt, and certainly reported by the media as a quote-unquote test case for where the civil rights movement is in 2021. So with all due respect, I would suggest, whether it's intended or not, that inevitably a juror is going to be influenced by their presence in this courtroom. And while there seems to be some argument over how much the jurors can see, and I can certainly supplement the record, but I took pictures last week, and it is very clear that most of the jurors have a complete unobstructed view of the entire gallery. And again, we are concerned about our client's right to have a fair trial and the impact of the presence of these individuals is going to have on this case. And we are asking the court, and again, with all respect to the Honorable Reverend Jesse Jackson, that he be observing these proceedings from the jury assembly room where they are being streamed live, rather than sitting here in the courtroom where he can visually interact with the jurors in this case.
Anything from the remaining defendants?
Leon.
No. Anything from the state?
No, Your Honor.
All right. Mr. Gough, at this point, I'm not exactly sure what you're doing. I have already ruled on this court's position with regard to the gallery. And with all candor, I was not even aware that Reverend Jackson was in the courtroom until you started your motion. I have indicated the court's position. The court's position hasn't changed. At this point, it's almost as if you're just trying to continue this for purposes other than just bringing it to the court's attention. And I find that objectionable from the court standpoint. I have said over and over and over in this trial that I am attempting to ensure that in this courtroom that the defendants receive a fair trial, and I will continue to do that. I have heard the objection. I have ruled previously on my position with regard to the gallery, and that is unchanged.
And I'm not questioning the court's ruling, but the court, I'm
done talking about it, Mr. Gough. I've heard the motion. I understand what your position is, and if it's simply just to point out that an individual is in the gallery, it has been done.
Do I understand that I'm not to do that again?
I'm telling you that the court's position has remained the court's position, and unless anyone in the gallery is disruptive or here to cause some demonstration that will distract from the presentation of evidence in this case, the court is not going to single out any particular individual or group of individual as not being allowed to be in this courtroom as a member of the public. That is consistent with my prior ruling and will remain the ruling of the court. If there's a disruption, you're more than welcome to call that to my attention. If there's a problem, call that to my attention. But on this particular issue that you brought up previously, which has now been effectively renewed, I think I've been very clear we do not need to discuss it any further.
And I've been very clear of my desire to make a record. And thank you, Your Honor.
Is the state ready to proceed?
Yes, Your Honor.
All right, let's go ahead and get the panel. All right, welcome back. We are ready to proceed with the evidence in this case. State ready with its next witness.
State's ready. State calls Carol Flowers, Judge.
Swear to tell the truth, whole truth, and nothing but the truth.
I do.
Go ahead and have a seat.
morning, Ms. Flowers.
Good morning.
Can you go ahead and introduce yourself to the jury? Just tell them your name and then spell it for the court reporter, please.
Carol Flowers, Carol Flowers.
Okay, and how are you today?
I'm good.
Good, good. So, do you live in Brunswick?
I do.
Okay. What part of town do you live in?
Boykin Ridge.
Okay, that Boykin Ridge area?
Yes.
Okay. Is that close to like the Fancy Bluff area?
Yes.
Okay. And are you married, single?
I'm married.
Okay. Do you have any children?
I do. I have 2 biological children and 1 stepdaughter.
Okay. How old are your kids?
28, 24, and 19.
Grown kids.
Grown kids.
Okay. And what do you do for a living, Ms. Flowers?
I'm a nurse.
Okay. I want to turn your attention to a person by the name of Ahmad Arbery. Did you know that person?
Yes.
Okay. Can you tell us how you knew him?
He was my neighbor.
Okay. Are we talking like next door neighbor?
Yes. Right
Okay.
next door.
Right next door. Okay. Do you remember when you first met him?
In late 2011 or early 2012.
Okay. May I approach, Your Honor?
Yes.
All right, Ms. Flowers, I am approaching you with what has been marked for identification purposes as State's Exhibit 1. If you can look at that and just tell me if you recognize it.
Yes.
Okay, who's that depicted in the picture?
Quiz.
Okay. And you say Quez. Is that what you knew him as?
Yes.
Okay. Ay, ay, ay. Thank you. Couldn't do it without you. And is it a fair and accurate depiction of Mr. Arbery?
Yes.
Okay. At this time, we would tender States 1. Thank you.
Objection. Greg McMichael?
No objection.
Submitted.
Permission to publish, Judge?
Go ahead.
Okay. All right. So, Ms. Flowers, that's who you knew as your next door neighbor?
Yes.
Okay. Now, do you remember the day that he died?
Yes.
Okay. All right. That is all I have for you, Ms. Flowers. The defense attorneys might have some questions for you, okay?
Okay.
I do have brief questions, but I think we need a recess, Your Honor.
Ladies and gentlemen, if we could just take a moment, if we take a 5-minute recess.
All right for the jury.
All right, I took a recess because, that's okay. All right, I'm just taking a recess. There was a little bit of commotion in the back. I wanted it to calm down a little bit before we started with any cross-examination.
And Your Honor, for the record, I would note that the Reverend Jesse Jackson's mask is down below his nose, which I'm not a big believer in masks, but we, again, make that part of the record. And I'm sure the court can see what I'm talking about.
All right, it appears we have order back in the court. Let's get the panel.
Your Honor, may we approach?
The jury's not, I'll ask the witness to step down. Ma'am, if you could go ahead and take a step into the hallway for just a moment. Okay, the witness is not present. Ms. Hook.
Your Honor, is there a way we can do this at the bench, or
No, we're making a public record of this. I adjourned because when the state was done, I heard some weeping in the back. And was looking at the defense to move forward, and there seemed to be an indication that we should take a pause, so I decided to take a pause. That is all. I have order back in the courtroom now, so I tend to move forward.
And Your Honor, for purposes of the record, I will have to note that I observed a number of jurors looking back, and that's why this is so difficult, Your Honor. We are advocates for our clients, but we are also human beings and parents. And there is no disrespect intended in these remarks, but my one and only purpose is to assure a fair murder trial for Mr. McMichael. And when jurors hear the weeping with a piece of evidence that is absolutely irrelevant and has nothing to do with the decisions this jury must make, but the law of Georgia allows it to come in, and then left with having jurors hear and see and visualize the emotion, and now to be comforted by someone for whom respect abounds. We're in a very difficult position now with this jury to have seen and heard and felt that when they go back to deliberate this case and to think about the decisions that do matter in this case. And as beautiful of an in-life photo as that is, it bears no relevance to any issue in this case. So while I appreciate the court taking a break and noting your having heard the crying up at the bench, I have to place on the record that not only did I hear it as well, I saw jurors looking back at what was going on in the gallery and then looking at me. So I'm asking the court to place that on the record. Mr. Gough and I may not agree on a number of things, but the idea that this may not be the best way to handle this sort of case has become now the issue that you asked him to bring to your attention, and that is, has there been any disturbance caused by that presence?
If I could just add, Your Honor was very aware of the issue of emotion in the courtroom and how it plays out in front of the jury. And I think went on the public record and warned the gallery not to engage in that kind of behavior, and I think instructed all of us to make our witnesses aware of any evidence that might come in that would cause that kind of emotional outburst, and did so with the goal in mind of keeping this trial about the evidence. It's becoming less and less about evidence and more about emotion with these kinds of outbursts and those kinds of photographs, which, again, to echo Ms. Hogue, have nothing to do with the issues in this case. A photograph that's 8 years old and bears no real resemblance to the person we saw in February of 2020. So I would join Ms. Hogue's difficult position. I think we're all in that same position on this side of the courtroom.
And I can state.
No, Your Honor.
All right. So let me tell you where we are. I heard at the bench, some weeping, not outward crying, not yelling, nothing along those lines. So the jury was asked to leave, and this was intended to, and I think is a good reminder to the gallery that there shouldn't be any outbursts, no matter what the evidence is, whether it's this photograph or anything else. But I will point out, with what's now beginning to happen here, I do not understand, Mr. Gough, why this motion keeps being made. It is a concern to the court because on the flip side, I've seen a news report where other counsel are indicating that everybody is welcome, come one, come all. We've got a little bit of, there's an odd thing going on here that I'm watching to make sure that I've got a clear understanding of as we move forward in this trial. And I've already put my rulings on the record with regard to public access in this courtroom. That has now somehow got conflated with a photograph that was not objected to as it came into evidence. I understand the defense.
It was objected to previously, Your Honor.
That particular photograph. Okay, and that's fair enough. And I misspoke there. And I misspoke. But the point being that there's other evidence that comes in, elicits responses. I've got issues that are starting to get conflated, and we'll watch what's going on. The court's rulings, again, on public access haven't changed. The evidence is being admitted. It is an emotional trial. That is not unique when it comes to murder trials, which is why the court prefaces a lot of murder trials with, I don't want any outbursts from the gallery. So again, to the gallery, I don't want any outbursts from the gallery. This is not the place for it. We're trying to get a fair trial for the defendants and ensure that the evidence gets presented in such a way where counsel have the opportunity at some point, hopefully in the near future, to make an argument to the panel about what the evidence actually says happened on the day or days involved here. That's what we're doing. And I don't have anything else to say about it, Mr. Gough.
I might suggest that the court consider some Supreme Court precedent.
On access to the courtroom?
Maxwell v. Shepherd, Stella v. Texas, and I don't remember the other name of the party, but Musladeen, and Justice Souter's concurrence.
Well, why don't you tell me what your understanding of it is, and then I'll go ahead and take a look at it, or give me the full cite if you're going to ask this court to do something in the form of a motion. If you're not moving the court to do something, I'm not terribly interested in continuing this conversation.
Your Honor, I will file a written motion as soon as I can finish it. You might well imagine that we're talking about issues that we don't ordinarily encounter, even in a criminal case.
Well, don't throw up a trial balloon without some support at this point. If you think that those cases in this context move the court to do something, cite them, let me know what it is, and we'll move on from there. Because I've heard a lot of discussion here, and this is the first you're now citing case law on this. So, if you want to file something, go ahead and file it.
Thank you, Your Honor.
Thank you. Is the state ready with, I'm sorry, it's not even ready. Let's get the witness back up. State had passed the witness, yeah. And let me back it up. If you're moving for a mistrial, you need to move for a mistrial.
I move for mistrial.
Based on?
Based on the presence of people in the courtroom and the public gallery.
Your Honor, I have to stop for one moment. We have a witness now on the stand.
If you go ahead and sit down, thank you.
Thank you.
And I do actually very much appreciate the court helping me maintain a record on this. We formally moved for a mistrial under the 5th, 6th, and 14th Amendments of the U.S. Constitution, parallel provisions of the Constitution of the state of Georgia. We contend that the atmosphere of the trial, both inside and outside the courtroom, at this point has deprived Mr. Bryan of his right to a fair trial. I understand that co-counsel vehemently disagree on some aspects of that motion, and if they don't want to join, that's their business. But I represent Mr. Bryan, and my concern, Your Honor, notwithstanding what in my observation would be extraordinary efforts on the part of the court to avoid anything that would interfere with the right of these defendants to a fair trial. At the same time, in extraordinary cases like this, additional steps have to be taken. We have not secured the front of this courthouse. The Transformative Justice Coalition still flies their banner virtually every day outside in what should be protected grounds. Your Honor, we have had numerous instances several instances during jury selection of nonverbal communications between the victim's family and jurors or from juror to the victim's family. We've had several emotional outbursts during the trial of this case, notwithstanding the substantial efforts of the court to ensure that they don't take place. And we have had civil rights icons sitting in here in what the civil rights community contends is a quote-unquote test case for civil rights in the United States, eyeballing these jurors, including one today with his mask down, which the court doesn't want to make part of the record, under Supreme... I
You just
rephrased
took that a
that,
little
didn't
too
make
far.
part of the record.
Thank you.
Yeah, I rephrased.
You made it part of the record.
Well, until the court acknowledges it, it's not part of the record.
Keep going, Mr. Gough.
Your Honor, the case law out there in mob cases and other cases demonstrates all the ways that presence in a gallery can influence jurors in a case. And I certainly don't mean to suggest that Al Sharpton or Jesse Jackson or any other pastor belong to a mob, but at the same time, we are talking about organized behavior by whoever outside the courthouse leading up to this case, where we have all these community leaders fearful that the city's going to burn down. This isn't a mob case. If you testify against a gangster, they might burn your house down. They might burn your business down. They're not going to burn your whole city down. And that is the concern that I believe jurors have expressed during the voir dire process, in that a county commissioner, a mayor, school board member, a bunch of pastors in this community, both black and white, have been talking about. So in that context, we believe the totality of the circumstances, which is what this court looks at under Shepard v. Maxwell, under the totality of circumstances, this trial has been sufficiently infected, notwithstanding the best efforts of the court, to the point where Mr. Bryan's ability to receive a fair trial has become an open question. We think that line's been crossed. The court may see it differently, but we've made that for purposes of the record.
Just briefly, Judge. On behalf of Travis McMichael, we're constrained to join. I did notice jurors, a few, noticed the outburst. I don't think it gets any more difficult at moments like this for the family members to have to sit through the evidence. This moment feels unique in that the one piece of evidence that the state put up was not, so inflammatory, but there were several jurors that did look over. Their faces changed, the emotion, the sympathy that they felt. And to see then Mr. Reverend Jackson, whose autographed picture hung in my mother's law office for 2 decades, who is the ultimate figure of fairness and justice and equality. To see that, I don't think it gets any higher in terms of the impression that makes. And for those reasons, I think that makes this very unique. And that's why we're constrained to join, Your Honor. Thank you.
Likewise, on behalf of Greg McMichael, we are constrained to join this motion, but for some slightly different reasons I'd like to highlight. It was apparent from the beginning of voir dire that it was going to be difficult, even long before voir dire, that it was going to be difficult to get a jury who had informed opinions, and we worked very hard to do that. And we would have loved to have had a jury that represents the demographic composition of Glenn County, which would have been 3 or 4 African Americans on the jury. We were not able to do that. I think some comments by the court in denying the state's reverse Batson motion, I take exception to them, and with all due respect, but it's continued the difficulty we've had from the beginning in trying to determine, is this the right venue for this case? We hoped it would be. We wanted it to be. But in light of what's going on now and what has been the history of this case up to now, we are constrained to join the motion for mistrial, but for these slightly different reasons.
And Your Honor, let me be clear. I don't know what this talk about change of venue is. There's nothing wrong with this venue. We're not concerned about the venue, but we are concerned about the details as to how this trial has progressed, notwithstanding the extraordinary efforts that this court has made. And I certainly don't want the court to think for a moment that Mr. Bryan and I don't very much appreciate the incredible amount of work the court has put into this and the thoughtfulness. But if the court's not going to grant a mistrial, I would humbly urge the court to consider adopting other precautions to ensure that the court doesn't wind up where the court has to grant that motion.
Anything from the state?
Yes, Judge. A mistrial is a proper remedy for incurable fundamental unfairness in the proceedings. There's a case from 1999, Casey, C-A-S-E-Y versus the state, 237 Georgia App 461, where jurors briefly saw the defendant in handcuffs, and that did not require a mistrial because there was no showing of actual prejudice. Quickly looking today, right now on Lexis, what we have is also Byrd versus the state, B-Y-R-D. This is a Supreme Court of Georgia case from 1992. It's 262 Georgia 426. Basically holding that because the trial court took prompt, thorough, and curative action, the outburst of the victim's relative did not deny a defendant a fair and impartial trial, and his motion for mistrial was properly denied. This court obviously took prompt, thorough, and curative action by having the jury leave immediately. In addition, don't want to cite something before I actually read it, so I'm going to take a look at it. We have Simmons versus the state, 308 Georgia 327, a March 13th, 2020 case. Simmons contended that the trial court abused its discretion when it denied his motion for mistrial in response to, and they put these in quotes, emotional outbursts of the victim's family members and friends. However, the Georgia Supreme Court saw no abuse of discretion. They then cited two numerous cases there, stating that trial courts are vested with great discretion to grant or deny mistrials because they are in the best possible position to determine whether one is actually warranted or not. Measures to be taken as a result of demonstrations and outbursts which occur during the course of a trial are matters within the trial court's discretion. And of course, such discretion will not be disturbed upon appeal unless there's a showing that a mistrial is essential to the preservation of the right to a fair trial. This was minor weeping in the back, and the court took immediate curative action. Additional action can be taken to instruct the jury there to ignore any sort of emotional outbursts that take place. And at this time, Judge, we ask that you deny any sort of mistrial based on the outburst, or, well, it really wasn't an outburst. It was, in the state's position, it was kind of a gulp and a weep, like that. And that was basically all it was that the state heard. So I just want to make sure that characterization, it wasn't somebody shouting, it wasn't somebody, as they say, falling out hysterical, nothing along those lines at all. So we ask that you deny any motion for mistrial on that basis. And ask that the court take kind of into consideration the, and disregard the, how am I trying to say, the mixing up or confluence of multiple arguments about Reverend Jackson being here and that somehow having something to do with the outburst or something like this. These are all very, very separate issues, neither which independently or even together at the same time require manifest necessity for a mistrial. We ask that you deny that mistrial.
I believe that the last word.
Yes.
Roddie v. Shepherd, the court's looking at the totality of circumstances here. And under the totality of circumstances, we believe that a mistrial is warranted. I think the state has certainly accurately summarize the relevant law with respect to the court's discretion and with respect to whether an appeals court would reverse a determination by this court. But still, ultimately, it is Your Honor who makes that call. And that's why you get paid the big bucks, because you're the one sitting here as the umpire in the case, the advocates. We all see things from our perspective. You're the neutral here, and you make the call. But I would just admit, under the totality of circumstances in this case, from the commencement of jury selection to today, that these defendants can no longer get a fair trial.
It appears, Your Honor, there's some language in these cases about what is now incumbent upon the court. Until the state has to hold the trembling hand of the accused, I would suggest that these types of moments don't impact the state. They favor the state. And it is now incumbent upon the court to decide to grant mistrial or to present curative instruction.
I've asked for curative instruction as an alternative at this point.
Yeah, well, the idea that you have to then potentially inquire of jurors and ask them if they heard it and if they noticed it, we're not asking for that. However, we're at 2 strikes. We've had one outburst that's been addressed. Now we've had a second. The court has to decide what to do.
All right, anything final, Mr. Hunter?
No further comment.
All right, it's in this court's discretion with regard to any outburst in the courtroom, taking into consideration as well as the defendant's motion for a mistrial. So I cite to a couple cases. Let's see, Forney, I think it's Forney versus State, 255 Georgia 316, which actually recognizes that emotions are neither unreasonable nor unexpected during a murder trial. And the demonstrations and outbursts which occurred during the course of the trial are matters within the court's discretion to evaluate. The court heard exactly what I described on the record, decided to remove the jury briefly, and it was ready to get started. Based on that outburst, the court is not granting a mistrial. As to the totality of the circumstances argument, which I think is the second argument that was presented by Mr. Gough, that gets back to what I'm starting to watch very carefully as far as what's going on in this courtroom with the jury, as well as the arguments that are being made by counsel. I'll point out that a number of times during jury selection, it was raised that jurors were being influenced by individuals outside the court. And I think it was either 4 or 5 jurors were asked specifically whether or not they were influenced in some way by what was going on outside the courtroom. And they were not. There was no, actually, if I remember correctly, they didn't even recognize or see what was going on outside the courtroom. And as counsel are aware, because I have briefed counsel, there are steps being taken by the court during the jury trial to ensure that jurors are not influenced by anything happening around the courthouse. So then we start getting into what we have now with individual members or individuals coming into the courtroom. I will say that is directly in response, Mr. Gough, to statements you made, which I find reprehensible. The Colonel Sanders statement you made last week, I would suggest may be something that has influenced what is going on here. In response to that, and to his credit, Mr. Sheffield made some comments, but did say, come one, come all. And so now the court is faced with balancing a lot of things going on outside this courtroom and doing it in a way that respects members of the public's right to be in the courtroom, as well as what I'm trying to put out there is a fair trial, right? So you need to understand, everybody, that your words in this courtroom have an impact on a lot of what's going on. And so my measured response at this point is to balance all of that out and try to move forward with the trial. I'm not granting a mistrial at this point based on these arguments that are being made, because I think, well, I'm not granting a mistrial at this point based on the arguments that have been made. Are we ready with the witness from the state? Be Mr. Sheffield. All right, let's go ahead and get the panel.
All rise for the jury. Please be seated.
All right, welcome back, ladies and gentlemen. We are ready to get back to the evidence in the case. Mr. Sheffield.
Yes. Good morning, Ms. Flowers.
Good morning.
I'm Jason Sheffield. We have not met before, right?
No.
Okay. I know that you have had an opportunity to talk with a couple of people investigating this case, and they interviewed you, and I think that's how we learned that you were the neighbor to Mr. Arbery. Is that right?
Yes.
Okay. And I think you were shown a picture of Mr. Arbery from around the time of 2012, 2013.
Yes. Yes.
Okay. All right.
We're unable to hear.
If you would just speak up just a little
I'd
bit.
say, maybe just that microphone, it's very, it needs to be pointed right at you. Or if you try to speak into it.
I'm not sure when the picture was taken.
Oh, okay. All right. I want to show you a couple of the pictures. I've shown these already to opposing counsel. I've marked them as defendant's exhibit Travis McMichael 12 and 13 for identification purposes. May I approach Ms. Flowers? Thank you. Ms. Flowers, I'm going to hand these to you and just ask you if you recognize the person in these images. Will you take them from me? Do you recognize the person in Travis McMichael's exhibits 12 and 13?
Yes.
And who do you recognize that to be?
Quiz.
And are those fair and accurate depictions of him? Do those fairly and accurately
Yes.
show who he is?
Yes.
Okay. I move defendants exhibit 12 and 13 into evidence.
No objection.
Okay.
Okay.
All right. Very good. Permission to publish?
Yes.
Okay. I'm just going to show you defendants exhibit 12. And I'll show defendants exhibit 13. I don't have anything further. Thank you.
Anything from the additional defendants?
No, you are.
No, I'm sorry. Oh, I didn't read your
Nothing from the stage.
All right, thank you, ma'am. You may step down.
Thank you, ma'am.
From the state?
State calls Ann Kisler Rao.
Swear to tell the truth, the whole truth, and nothing but the truth.
Yes, I do.
Go ahead and see.
Good morning, ma'am. How are you doing today?
Good morning, fine, thanks.
Will you go ahead and state and spell your name for the record, please?
My name is Ann Kisler Rao, ANNEKISLER-RAO.
And ma'am, what do you do for a living?
I'm employed with the Georgia Bureau of Investigation, Division of Forensic Sciences, also known as the State Crime Lab, and I'm employed in the Trace Evidence section.
Okay. And what is the trace evidence section of the GBI?
With the Trace Evidence section, we analyze small, often microscopic pieces of evidence such as hairs, fibers, paint, glass, fractured materials, and general unknowns.
And your specific occupation, is there a term for your job?
I am a microanalyst.
And tell the jurors a little bit about your training and your education in trace evidence and microanalysis.
I have a bachelor's degree in biology from the University of Pennsylvania. I have a master's degree in forensic science from John Jay College. While I was there, I completed an internship with the New York City Police Department Crime Lab. I have been employed with the GBI Crime Lab for over 15 years, and I've completed extensive training programs in all of the areas that I perform examinations in. And I'm also certified by the American Board of Criminalistics in hair and fiber analysis.
And does your certification require you to keep up to date on the current subject matter within your area of expertise, take any sort of continuing learning, education hours, or anything of that sort?
That's correct. We have to have certain things like continuing education to fulfill points over the certification period.
And how long have you been a microanalyst?
For over 15 years.
During the course of those 15 years, have you continued to keep up your certification and your hours and your continuing education?
Yes, I have.
This might be a tough question, but do you happen to know or have a rough estimate about the number of cases you've done analysis on in your time in the GBI?
Probably over 1,000 cases.
And during the course of your employment with the GBI, have you come to court to testify at maybe hearings or trials, that sort of thing?
Yes, I have.
And have you ever been tendered as an expert before in the court from the state of Georgia?
I have.
You know roughly how many times?
Over 50 times.
Judge, at this time, the state tenders Ms. Kisler Rao as an expert in trace evidence and microanalysis.
No objection.
No objection.
No objection. She's admitted.
Thank you, Your Honor. Were you asked to perform some sort of analysis for the case involving Ahmad Arbery?
I was.
Okay. How many different analyses did you have to do for this case?
There were 2 analyses that were requested.
Okay. Let's start with the first one. What was the first one you were asked to do?
The first one was a fiber analysis.
Okay. And can you give the jurors a condensed or a simplified version of what fiber analysis is?
Fiber analysis is typically going to be, we will compare question fibers, which are fibers that are collected off of an item of interest where we don't know what their source is. And we'll compare those to a known source such as an article of clothing, and determine whether or not those question fibers are consistent with the known source.
Okay. When you're comparing fibers, do the types of fibers matter when it comes to comparison?
Yes, we can compare any type of fiber.
Can you explain to the jurors a little bit more about maybe the difference between natural and synthetic fibers, and maybe the ease with which those types of fibers are able to be compared?
Yes, so when we perform a comparison, we go through a number of different steps in our comparison. The first step is using a stereo microscope, which is a low-powered microscope. We use that to examine the general features of the fibers. So this can be done with both synthetic and natural fibers. The next step is the comparison microscope, which is a higher-powered microscope. There are two microscopes that are connected together by an optical bridge where we can see the question fiber and the known fiber at the same time under the same field of view. With natural fibers, we can look at the morphology of the fiber, so you can look at the general shape of the fiber to identify it. If the fiber is colored, you can look at that with both natural and synthetic fibers. With synthetic fibers, there are going to be extra features that you can examine, such as during the manufacturing process, they might add particles called delusterant to the fiber. They can have different cross-sectional shapes to the fiber. There are many different fiber types that you can have, like nylon or polyester. So these are the first two steps of our procedure, and those would be the differences that we would look at between natural and synthetic fibers.
Now, is this a multi-step procedure besides those first two?
It is.
What else do you have to do?
The next step would be fluorescence microscopy, which is another comparison microscope where we'll shine different wavelengths of light on the fibers, and different fibers can fluoresce different colors and different intensities, like bright or dull. After that, the next step is called microspectrophotometry, or MSP for short, and this is done with dyed fibers, and it is basically an instrumental technique that you can use to analyze the color of the fibers. So fibers that appear the same color under the regular microscope might give different spectra using this technique. The next step we have is called Fourier transform infrared microspectroscopy, or FTIR for short. And this is done with manufactured fibers, and it can help determine the chemical structure of the fiber, and it will help you confirm what kind of fiber you have. And we can also do a melting point analysis with fibers that melt to compare the melting features of the fiber.
Now, you put out a lot of terms for us, okay? So during these various steps, are these steps required in every analysis, or can you tell based on maybe a visual cue which steps you might have to take in each analysis?
So depending on what type of fiber you have, you would not complete all of the steps. So for example, if your fiber is not dyed, we would not necessarily be doing the MSP step to analyze the color. If the fiber is a natural fiber, we would not be doing the FTIR to analyze the structure of the fiber, because we can tell that is natural based on microscopy alone.
And in the fiber analysis that you did for this case, were you given a potential sample of fiber to look at?
I was.
Okay. And can you tell the jurors what came into your office and where they came from, and what you did to compare the fibers that came through and then your results?
Okay. So what was submitted to me was what's called a tape lift. So it's where you take a piece of tape to collect fibers on an item, and that'll collect any fiber on the surface of the item. It was submitted by a police department. And then I also received a white t-shirt, which was submitted by our medical examiner's office. And I compared the question fibers. I took a sampling of the question fibers from the tape lift. I compared 20 of these fibers to the known fibers of the t-shirt. I found that they were consistent in microscopic properties and fluorescence. These were white cotton fibers, so I did not go on to the next step in the procedure because they were not dyed and they were a natural fiber. And I found that the question fibers were consistent with the known fibers composing the t-shirt. So I could not eliminate these fibers as coming from the t-shirt. I reached this conclusion because white cotton fibers are a common fiber type and they are prevalent and they do have limited features for comparison. However, they were consistent.
So when you say cannot be eliminated as having come from the t-shirt, does that mean that they definitively came from the t-shirt?
I cannot say that they definitively came from the t-shirt. There could be another source possessing fibers that would also be indistinguishable from these.
But they were similar in characteristics.
They were consistent in all of their microscopic properties as well as their fluorescence.
Do you know where this take lift came from in terms of evidentiary chain of custody, that sort of thing?
I can tell you like where it originally came from, who submitted it to us, is that
Who
what you're
submitted
asking?
to it and where it actually came from in terms of the crime scene, if you know, and whether it's listed in your reporting?
It was identified to us as having being taken off of a truck.
And do you know the police department that submitted it to you?
May I refer to minutes?
You can.
It was submitted by the Glenn County Police Department.
And in your job, you get submissions from all over the state, is that right?
We do.
While we're talking about fibers, are fibers transferable between different objects?
Yes, they are. Anytime any two objects come into contact with each other, there's the potential for fibers to transfer off of one item onto the other and vice versa.
Like if you have a sweatshirt on or a sweater on and you take it off, there might be some fibers on the t-shirt underneath. Is that what
Yes,
we're talking about?
that's correct.
Now, do these fibers, does it matter what the object is in order for a transfer to happen? Are some objects easier to get transfer onto?
So generally speaking, the items are...
Objection, relevance, and generally speaking. If she has an opinion about this particular case, we'd like to hear it.
I can narrow it down, but I mean, I think in general, she's able to explain the process of transfer, and then we can narrow it to a specific part of this case.
Again, if she's going to render opinions in this case on this evidence, that's great, we want to hear it. If she's just going to generally talk about things that are not relevant to this case, then we would object.
I understood the question. She was explaining the process. If that's the case, great. But if we're just talking about other cases generally or other experience outside of this case, it's sustained. But if it is to explain her method or opinion, why don't you just restate the question?
Sure. Do you know how easy it would be to transfer cotton-type fibers to a truck?
Object to the form of the question. If she's got an opinion to a reasonable degree of professional certainty, that's fine. But if this is anecdotal testimony from personal observations that are not peer-reviewed, we've got a problem with that.
She tested the fibers.
She tested the fibers.
It's sustained.
When fibers are transferred from a garment to another object, you have to take into account the texture of the items in question. So for example, a fuzzy sweater is going to transfer fibers a lot more easily than say a windbreaker jacket. So a t-shirt would be somewhere in the middle. When you're transferring onto a hard surface, there's less likely to transfer a lot of fibers onto a smooth hard surface like a car than it would be onto like a more textured surface.
does the amount of fibers left behind on an object have any correlation to strength of, let me rephrase it.
Your Honor, I'm going to object and suggest we take this matter up outside the presence of the jury.
What's the objection, Mr. Gough?
Your Honor, if she has an opinion to a reasonable degree of professional certainty, I have no problem with that. But this is a fishing expedition, I object to it. I'm just looking, and I'm basing that based on the report I received in this case.
As long as
I have
she
one
needs to,
question.
she needs to present a foundation, you can testify as long as there's a foundation. Go ahead.
Are you able to determine how long an object was on another object based on the amount of fibers left? Generally, science-based.
I cannot determine with absolute certainty how long items were in contact. I can say that the longer that items are in contact, the more likely there is to be more fibers transferred.
Let's talk about the second analysis you did, okay? What was that second analysis?
I was asked to perform a general materials analysis, which is basically the identification of an unknown material.
Okay. And where did that material come from that you were asked to analyze?
It was identified as coming from the armpit of the body
And the body of whom?
of Ahmad Arbery.
And what analysis did you perform and what were your results?
I performed, so I examined the material using our stereo microscope, our low powered microscope, and also a higher powered microscope. I also analyzed it using the instrumental technique I mentioned before, FTIR, to look at the structure of the material. And I found that it was characteristic of botanical material. So this is plant material. It can be things like wood or bark or leaves, pine straw, that type of material.
And where did you receive this material from again?
This material was received from our medical examiner's office.
And once you're done with your analysis of any case that you get in, okay, once you're done, does it go through a secondary process to determine whether or not you believe that, you know, it was accurate and that sort of thing?
Yes, every case it goes through a peer review process, so a second examiner will look at all of our notes and data and our report and make sure everything supports the findings.
And was that done in this case?
It was.
And do you believe that you followed all your standard protocols and procedures when it came to both of these analyses?
I did.
And once you're done doing the analysis, do you document your findings in some sort of report or notes?
Yes, I have notes for the case file that we retain in our computer system, and then I will issue a report on the matter.
And did you do that in this case?
I did.
And for the purposes of the record, what is your case number for both of your reports?
The case number is 2020-6001183.
Just one moment. Ms. Kisler, do you happen to know where that botanical matter came from?
It was identified to us as having come from
You said the armpit was
the
under?
left armpit area.
Okay. But before that, you don't know where it came from?
No, I do not.
Judge, at this time, the state will pass the witness subject to redirect.
Anything contrasting?
No, Your Honor.
No, Your Honor.
Mr. Brown?
Yes, Your Honor. Good afternoon, young lady.
Good afternoon.
My name's Kevin Gough. I represent Mr. Bryan. I have just a few questions for you.
Okay.
A moment ago, did I hear you tell the jury that, excuse me, that you can't say definitely that the cotton fibers came from the shirt attributed to Mr. Arbery?
That's correct.
Okay. But your report doesn't say, that's not the words in your report, are they?
I reported out that I could not eliminate these fibers as having come from the shirt.
Okay. Well, would you not agree there's a huge chasm between the words in your report about you can't eliminate the possibility that the fibers came from the shirt to today when you say that you can't say definitively that they did come from the shirt? Those are conclusions in two completely opposite directions, aren't they?
Well, no, so I can't eliminate those as having come from the shirt. That is also true that I can't say they absolutely did come from the shirt. Those are not exclusionary of each other.
Logically, they're not, but they certainly convey different ideas, don't they?
I hope that I have conveyed properly the idea that I cannot eliminate these.
And of course, you examined fibers that were identified as having come from the driver's side of truck, correct?
Yes, that is what they were identified to us
You were
as.
not asked to examine or compare any fibers recovered from either the front or the back of that truck.
To my knowledge, no other fibers were recovered.
Okay. Now, sheet metal is a smoother surface.
That's correct.
I believe that's what you were referring to earlier.
Yes.
What about grills? Are they all smooth?
They have a smooth surface. Potentially things could get caught in areas of a grill.
Hood ornaments, also not smooth.
They do have some sharper edges.
Bumpers have sharper edges.
Again, depending on the area.
Back bumpers have sharper edges.
They can.
Okay. So in the end, I think, correct me if I'm wrong, what you've told the jury, essentially, stripped of everything else, is that these fibers may or may not have come from Mr. Arbery's shirt.
They are consistent in all their properties. They could have come from this shirt, but they also could have come from another source possessing fibers of the same characteristics.
All right. Thank you, ma'am. No further questions.
Any redirect from the state?
No, Judge.
Thank you, ma'am. You may step down. She also subject to recall?
No, Judge, we're okay on that.
All right. You are released. Thank you, ma'am.
I thought we were keeping all the witnesses subject to recall.
If you want her, we can keep her, but.
We'll keep her subject to recall.
She just walked out the room. We want to make sure someone gets her the message.
We know where she works.
Figure we can find her. Okay. Ladies and gentlemen, we're a good place to break for lunch. We're going to take a 1-hour recess. Enjoy your lunch. We'll see you back here right about 1 o'clock for a continuation of the evidence in this case.
All rise for the jury. Please be seated.
All right. Anything from the state before we recess?
No, Judge, nothing from the state.
From Travis McMichael?
No, Your Honor.
From Greg McMichael?
No, Your Honor.
From Mr. Bryan?
No, Your Honor.
We're in recess until 1 o'clock.